Good day to you and welcome to another Paddocks Club video tutorial. Today I want to talk about agreements for the keeping of pets in sectional title schemes. Most schemes have either the original prescribed conduct rule 1 or an amended version of that. But in most schemes, and those that I'll be discussing today, owners and occupiers do have the right to keep pets subject to the condition that the trustees give them specific permission and that it can be withdrawn. The idea is that in addition to such a consent, an owner or occupier who wants to keep a pet should be required to enter into a specific agreement. And I'm going to go through what I think might be in such an agreement, and just to give you an idea of what I have in mind. Firstly, the agreement would draw the pet owner's attention to Conduct Rule 1, perhaps even setting out the terms of that rule. Secondly, the pet owner would agree to abide the rules of the scheme in regard to the keeping of the pet. Thirdly, the pet owner might undertake to monitor the noise from the pet, ensuring that it doesn't unreasonably cause annoyance or disturbance to neighbours, in contradiction of the obligations of all owners and occupiers in terms of the Act. The pet owner might undertake to maintain high standards of cleanliness and sanitation, cleaning and disposing of any animal waste within the section or the common property, and to maintain a high standard of preventative health, for example, in regard to flea and worm treatment. Finally, an undertaking that would make sense is to keep the pet under control at all times within the section or common property. The agreement might go on to acknowledge that the pet owner will be liable for any damage to the common property caused by the pet and shall pay the body corporate immediately for any costs incurred in rectifying that damage. It might have the pet owner accepting full responsibility and indemnifying the body corporate for any claim for injuries to third parties or their property that are caused by the actions of that pet. It might have the pet owner acknowledging that the consent of the body corporate operates only in respect of a specific nominated pet, and that a change of pet must be subject to a separate application. The pet owner might acknowledge that in the event of a breach of this agreement or the rules, the body corporate may withdraw any consent it has given, and finally agree that if the trustees do decide that their pet is dangerous, they will remove it immediately from the scheme. Why do I suggest that this might be a good idea? Are these things all obvious? Well, not to everyone, and I suggest that an agreement signed by a prospective keeper of a pet in a sectional title scheme that incorporates these aspects might be a very useful tool in the hands of the body corporate if it comes to the situation where the pet is a problem and does need to be removed. Thank you for joining me, and if you have any questions, let's deal with them in the discussion forum.